Okay, continuing here in equal rights, we're on slide number 38 of the PowerPoint. Let's talk about other disadvantaged group. Let's talk about help for us old guys. Okay, let's go in that direction. So, we're going to look at a court case that dealt with, do older people have rights like African Americans? Okay, could they be considered a suspect class? Okay, and again, it is in the environment of when people get older, there can be a tendency for employers to remove them, not necessarily fire them, but let them go for other reasons, okay? Why would they do that? Why would an employer do that? Because it costs a company more money to keep an older person who has been working for 20, 30, 40 years, who is making more money, has got a lot more benefits, right? Has got a lot more maybe contributed to the retirement plan. It's more expensive for an employer to keep an older person employed. And so it is the ploy, the strategy of companies when things get tough and tight to let go of the older people first, or at least they'll do it. They may not say they're doing it for that reason, but they'll do it. And again, a little bit of anecdotal information here. When I first got married back in 1991, I worked for a company called Zenith Data Systems in St. Joe. And they were bought out by a foreign company, a French company. And the French company was putting the squeeze on the American company. And they were letting go different, lots of people. We went from 1,800 people working there till it was, I think, 500. It just got way down. And so I remember I just got married and, just find out, hey, there's going to be layoffs at your company. So I'm just like, great. My dad said, man, that's going to be a great punch in the nose for you. Hey, you got married and now you don't have a job and you got to tell your new wife that. That's going to go down like a rat sandwich. But I remember, I was all concerned about all these layoffs and they happened. And I kept my job. Now, I was a 23-year-old pup, right? Just a kid. But all these people that were in their late 40s, 50s, 60s were let go. And, it was hard for me because they were my friends. It was hard for me because they were people I've been working with. It was hard for me because they had wisdom and they had knowledge. And suddenly now you had this incredible brain drain. They're gone. Hey, I can't ask Joe about this particular issue because Joe's gone. So how do I figure this thing out? And it was very interesting that in trying to cut costs and save money in a tough economy, they cut a lot of workers that were older. Okay, so as we're talking about, help for us old guys, would the court and does the federal government recognize older people as a suspect class? You can't discriminate against them in the workforce. So if you go to slide 38 here, there was something passed called the Age Discrimination Act of 1975. There was also the Age Discrimination in Employment Act passed in 1967. It prohibited discrimination against older workers in hiring for jobs in which age is not a critical factor in performance, okay? And so how do you deal with that? Okay, there was a case called Massachusetts Board of Regents versus Murgia in 1976. It was an instance when a policeman who was an excellent in physical health unfortunately turned 50, okay? And according to the state law in Massachusetts, you are forced to retire at the age of 50, okay? The thinking is a 50-year-old is physically not going to be as fit and can handle, again, police work. It's not like you're just doing paperwork. You're going to have to, go on the street and bust people and all that kind of stuff. And so again, the thinking of the law was that it's a public good for the community to not have old timers out there, patrolling the beat. And so Murgia basically appealed. It went to the Supreme Court, and one of his arguments was, hey, older people were suspect class, okay, and we should be afforded constitutional protection, perhaps even, strict scrutiny. We don't know, okay? The court held that the Massachusetts law requiring, or allowing, in this case, the police to forcibly retire people at 50, it did not violate the Equal Protection Clause. The court found that the right of government employment was not per se fundamental, and that uniformed police officers over 50 did not constitute a suspect class under the clause. Applying a rational relationship test, the court reasoned that the statute was sufficiently justified as a means of protecting the public by assuring physical preparedness of the uniformed police. The court noted that while the law may not have been the best means to accomplish this purpose, it did not violate the 14th Amendment merely because of its imperfections. So, bottom line is no help for us old guys, okay, in that way. If there's a rationally related means of creating a law, again, there was a rational reason. It wasn't just, hey, you're old, get out of here. But the thinking is, you want probably younger people patrolling the beat and things like that. If you got to get in a foot race, hey, I run. I'm running now. I probably average 25 to 30 miles a week. Okay, I'm 53. I might be able to take you. I don't know. But the point is, if you're younger, you can handle it better. And so there's a rational basis for that the court reasoned with. Okay, other disadvantaged groups. Okay. Go to page 40, or I'm sorry, slide number 40. How about disabled people? Okay, in 1990, Congress passed the Americans with Disabilities Act. So government entities must provide access for, handicapped people. Okay, all these handicap ramps at businesses. Okay, go to a grocery store, see all the handicap parking. Okay, all of that came because of that law. Okay, so it begs the question then, do handicapped people enjoy some form of privileged status? Okay, again, we're concluding here in this chapter. We began with the debate of Harris and Bergeron, right? Equality of opportunity versus equality of outcome. And a lot of these issues we've talked about, from affirmative action to, many of these other areas, they deal with equality of outcome. Okay, so we're going to look at a case here called PGA Tour versus Martin in 2001. Okay, kind of interesting. It was a case involving an individual by the name of Casey Martin. He was a very, very good golfer, but he had a degenerative circulatory disorder that prevented him from walking golf courses. So he was in the process of trying out for the PGA Tour, but he asked that, hey, even though you require walking, I can golf, but I can't walk, not that long, not that far. I'm going to use a golf cart, okay? And so he argued that my disorder constituted a disability under the American with Disabilities Act of 1990. And so the PGA Tour refused, and so he filed suit, okay? And again, the argument here is, if you go to slide number 42, does the American with Disabilities Act of 1990 provide access to professional golf tournaments by a qualified entrant with a disability? Okay, may a disabled contestant be denied the use of a golf cart because it would fundamentally alter the nature of tournaments to allow him to ride when all the other contestants must walk? Okay, if you're not a golf fan, think it through. Okay, somebody's handicapped and must be allowed to pitch in baseball, or must be allowed to play linebacker in football, or must be allowed to, to play or to make the roster of a basketball team, even though they're handicapped. Okay, in other words, how far does this equality go? Okay, now you're getting, to some degree, kind of the argument of Kurt Vonnegut in Harris and Bergeron, because this particular case, it made it to the Supreme Court, which is really interesting because technically the Supreme Court is supposed to deal with pretty significant controversies. When you're dealing with controversies in the sports realm, it's usually something the court doesn't get involved in, but they did. Okay, so the court decided for Martin, okay, in a 7-2 decision. And so the court held that Title III of the ADA, by its plain terms, prohibits the PGA Tour from denying Martin equal access to its tours on the basis of his disability, and that allowed Martin to use a cart despite the walking rule. And it's not a modification that would fundamentally alter the nature of the game. So they thought that, hey, if you use the cart, that's not going to fundamentally alter the nature of the game. They said the purpose of the walking rule is not compromised by the slightest by allowing Martin to use a card. So kind of interesting tour there, or interesting decision about this, okay? One of the dissents is kind of interesting because, again, you know, this opens a whole Pandora's box, okay, far beyond Casey Martin, is that if there are handicapped individuals in sports, should they be allowed to compete on the same level? Now you're into, to some degree, equality of outcome, okay, or at least getting close there. So I'm going to read the dissent of Antonin Scalia because I think he raises some interesting points, and again, it's funny. Okay, so here's what he says on slide number 43, his dissent in PGA Tour versus Martin. You can tell the sarcasm here. Then we justices must confront what is indeed an awesome responsibility. It has been rendered the solemn duty of the Supreme Court of the United States, laid upon it by Congress in pursuance of the federal government's power to regulate commerce with foreign nations and among the several states, to decide, based on U.S. Constitution Article 1, Clause 8, Section 8, Clause 3, to decide what is golf. I am sure that the framers of the Constitution, aware of the 1457 Edict of King James II of Scotland prohibiting golf because it interfered with the practice of archery, fully expected that sooner or later the paths of golf and government, the law and the links, would once again cross, and that the judges of this august court would someday have to wrestle with an age-old jurisprudential question for which their several years of study in the law have so well prepared them. Is someone riding around in a golf course from shot to shot really a golfer? Kind of fun. It's Alice, go to the next slide. It's Alice in Wonderland determination that there are such things as judicially determinable essential and non-essential rules of a made-up game. And it's Animal Farm determination that fairness and the ADA mean that everyone gets to play by individualized rules, which will assure that no one's lack of ability, or at least no one's lack of ability so pronounced that it amounts to a disability, will be a handicap. The year was 2001, and everybody was finally equal. So he concludes with a zinger, and he's saying, listen, this decision is kind of going the logic of Harrison Bergeron. The equality of opportunity logic here is that when we start going in this way and we start, you know, where does it end? And how will we know when we get there? And will the people that are crying out for equality, when they get it, will they be satisfied or will they ask for more? Which then begs another question. Is it the role of government to make everyone equal? Is it the role of government to satisfy every human aspiration? Right? Now you're getting back to what Alexis de Tocqueville talked about in that section of Democracy in America we read earlier in this section, right? Soft despotism. Is that the principle of equality has caused everyone to look to the government for a solution, and it causes people to be in perpetual childhood instead of growing up. Okay, just kind of interesting there. I'll let you think about that. And I'll stop here and we'll conclude with one more video.